Hi, very good afternoon to everybody from India. Thank you very much for joining in. We'll start in about a minute from here. I think I'll take a minute in the interest of time because the session may go longer. I thought I'll take a minute to briefly introduce Eleanor, and then I think Eleanor can sort of maybe give a quick round of introduction when she's starting off in that sense. Eleanor, thank you for joining us. Eleanor, for everybody's clarity, is a very prominent attorney working out of Marks and Clark, London, and she has extensive experience in data protection across landscapes, across consulting companies and government entities as well. And, particularly with respect to enforcement as well as compliance on GDPR. And Eleanor can sort of give more examples and entities that she's represented over the years. But I think from ever since when GDPR came into practice, Eleanor has been very actively involved and kept herself abreast with the space, and therefore I thought it's a good time is what we thought when because India is getting towards DPDP compliance, and we were talking a few weeks back. We thought it'll be a good idea to try and see where GDPR and DPDP would sort of collide and overlap. And Eleanor was kind enough to accept the invitation to do a joint webinar. So Eleanor, thank you very much for joining in and taking your precious time out on almost the weekend.
Oh, Taryn, it's such a pleasure to be here. Good afternoon to you all. Yes, I'm really looking forward to this session. I think it's going to be really interesting. So delighted to be joining.
Thanks very much. So I will take about 10-15 minutes and sort of give a very quick background so that everybody is on the same page. And then I will have Eleanor sort of talk about how she's seen GDPR practically getting implemented across industries, not just in the UK, but across Europe, and what her practical take is for Indian entities. We have about 150 odd people who've registered for the webinar. So I hope there'll be more and more who will join in. But we'll quickly move forward. As we all know, the legislature is in place, the act is in place, and we are sort of getting towards companies getting more and more compliant towards it. So I will quickly split across my part of the session on these five aspects that I've mentioned, with more focus on the salient features of DPDP and a potential set of overlaps with the GDPR, which can be further enhanced by Eleanor. Now, at a very foundational level, these are the six things that the DPDP endeavors to protect or sort of give coverage over. The main intent is the importance of the right of privacy, and therefore whatever allows individuals or what we call as data principals to protect their information with regards to any information with regards to their name, gender, their account details, any specific set of details that will come in, where they've worked in the past, date of birth, any kind of KYC information. All of that information from time to time, as we all see, gets shared with tons of companies, right? With Google, with Amazon, with several other such companies that are installed on our apps. And we till date have never cared of how that particular data is used by those companies. And therefore, by virtue of such companies not being under a particular regulation, they have the free hand at this moment to try and share the data with any other third party, who then reaches out to us as marketing communications, or a regular phone call that we may receive with respect to maybe buying a property or any other such information that gets transpired out. So once your number and your details are in the public domain, it essentially gets out there, and the endeavor here is to protect that and give the right to an individual to control who the data goes to, how the data goes to, and within that, what part of data goes to which entities in that sense. And that's the main focus as regards DPDP is concerned. So as I've mentioned, one of the salient features is the purpose limitation in terms of what is the specific purpose for which I want to share the data. Am I sharing it with Amazon only so that they can better understand my buying behavior and give it to me? Or am I okay sharing it also so that they can give on their cloud services or to any other third parties for that matter? And then as a result of it, they reach out. So the ability to control that allows me to limit the purpose for which I, as a data principal or owner of the data, can essentially control the flow of that data. I've given some examples and I'll not go through all of them in the paucity of owing to time constraints, but the data minimization is the second feature where the intent is to only give what is actually required, and therefore it is called as data minimization. I might want to give more information to Amazon compared to Netflix, for example, and compared to another third entity where I only want them to know what my name and my number is, but perhaps not my email address or such data for that matter. Third is the transparency of it, so that whenever a data fiduciary, which is the entity that we'll get to know and we'll hear about, which is the entity with which the data is shared, which in this present case is Amazon, for example, who are they sharing the data with? What data are they sharing? For what purpose are they sharing? And what are the stakeholders with whom they are sharing it is the reason why, and is the reason and the intent with which the transparency becomes the third feature set, so that there is absolute clarity and the principal who owns the data knows the entity with which the data is being shared. The fourth feature would pertain to security, so that the data remains secure. And we've seen several instances in the last 6 months where tons of data, even cybersecurity companies like Juniper, for example, or a few Fortinet, for example, lost thousands and millions in account data as regards their customers are concerned, and all of that became public or basically misguided or sort of non-masked in that sense, and therefore accessible to other third parties without their authorization. So the ability to control and secure the data is the fourth very critical aspect, and every data fiduciary has to ensure that the data being shared is kept secure. The fifth is the individual rights of the principal, so that they can edit, correct, erase, withdraw the consent that they've given to the fiduciary, and take any other such action to control. Because I may be on Netflix today, but I may basically uninstall or stop using it. And therefore, for me to be able to withdraw that consent I've given to Netflix to use my private data or personal data for that matter is the right that is given to me under the DPDP, so that I can not just basically erase the data or withdraw the data, but I can also edit and control the manner of flow of that particular data set. And fifth is the accountability of the data fiduciary and the parties that are below it, right? Like, as I said, if we are giving the data to Amazon and they have a cloud service provider and they have Prime Video and they had other subsidiaries with which the data is shared, all of them are accountable either in the form of a data fiduciary or in the form of a data processor, who essentially is a party which is a vendor that would process data on behalf of or under instructions of the fiduciary. So their accountability, how they will be controlled, are all aspects that DPDP intends to control, so that the data owner, who's the principal of data, gets the right amount of ownership and ability to take a call on how his data or her data will essentially be used. Now, as I've introduced already, there are three major stakeholders in the process. There are five in total, six perhaps, but the three main ones would typically be the data principal, which is a person or an individual like me, could be a data fiduciary, which would be an entity in this case as the Amazon or Netflix or any other such party. And the third could be a data processor, which would then be guided to process data on behalf of the data fiduciary, or with whom the data fiduciary shares the data, obviously post consent of the data principal. And their respective rights and duties would typically then be taken care of. Any dispute that the data principal has to show their grievance, or if they're aggrieved with the fact that the data that's shared is not as per the consent or is being mishandled or misused in any manner, would typically go to the Data Protection Board, which is the tribunal that will adjudicate on such disputes and impose penalties upon the fiduciary and or the processor if the need arises. And then there'll be a third party, which will not be any of these four parties, which will be contracted to enable the data principal not to go to every single fiduciary, because I may on my phone, for example, have 30 apps, and I may use tens of other websites as regards my email and my AI platforms and whatever you have you as regards the platforms for me who have access to my data. So for me to control that data, instead of going to every fiduciary or instead of being expected to go to every fiduciary independently, there is a concept of a consent manager, which could be a third party entity that will have a platform on which a principal can come and control the data that he is given. He can withdraw the data, edit the data, change the rights that are given to one or more fiduciary as he wishes to. But instead of going to every fiduciary independently, because which will be an extensively hard task to accomplish, the consent manager will provide a platform where a principal can come in. He can look at all the entities to whom or with whom the data has been given, all the processors who have access to that particular data, and can, as a result of it, control that access by virtue of managing, reviewing, withdrawing whatever consent that they want to. Now, we've taken the liberty here to indicate that the consent, as all of us would appreciate, and as I've probably explained, has to be free. It has to be without any coercion. Now, with this comes a caveat where there are certain platforms who will ask you to accept their cookie information or allow them to store cookies or allow them to store certain data. And if we do not do it, they will not give us access to that particular platform. Now, this is a great contrast with how GDPR has allowed conditional access not to be a reason why or based on which the consent should be governed, for example. So any platform or a part of that platform, which could be a feature of a platform that actually requires the data in order to process that particular data, is the only feature that can be hidden or not given access to if the user does not consent. Now, for example, if I go to Amazon, I need not have an account unless I want to buy one or more items. But if I just intend to browse through the items, by virtue of that not requiring my data mandatorily for it to be processed, Amazon cannot, or should not for that matter, bar me from accessing that particular platform. Same goes for any other website where some content need not require personal data of a person for him to access that content, but some may require processing of data by virtue of enabling a transaction to flow through. So for those components or features or parts of a platform that do not require data processing to be done, we would not require consent to be warranted by the platform, is what also is a subcomponent of the free aspect of it. The other part of consent is that it has to be specific. It cannot be a very broad consent. It should very clearly indicate where the data, for what purpose it will be used, as we've exemplified here as well. It has to be informed. The disclosure has to be completely accurate, that this entity as a data fiduciary will share it only with these 3, 4, 5 other parties for that matter. For what purpose will they share? And if the data principal does not want it to be shared for one or more reason, or only wants part of the data to be shared, through the consent manager, he will be able to control that. The consent must be unconditional. It should not be subject to certain conditions. It has to be unambiguous, and it must be withdrawable to the extent that the withdrawal has to be as easy as getting the consent. So it cannot be that the withdrawal would require somebody to be calling up on a call center and requesting for a withdrawal to be done in 72 hours. As easy as was it for the fiduciary to take the consent, should be the similar principles applied for him to be able to withdraw it as regards the principal of the data or the owner of the data is concerned. Now, instead of talking about what kind of a notice a fiduciary has to give in order or while taking the consent or put up on his website, we've basically generated a sample notice that perhaps can be given by a fiduciary, which would, for example, indicate what kind of personal data on the left, as we see, would be collected by this hospital, as we have taken in an example of this patient called Rajesh Verma. And this section, point number 1, would indicate what personal data, why, and why do they collect and process the data, for what purposes do they collect it, with whom and which all entities will they share it with. So they have a diagnostic center, for example, they have an insurance company that they have tied up with, they have a payment gateway that they have tied up with, they have some external consultants or physicians that they have shared up with, there's a pharmacy, for example. All of this would be indicative of with whom they'll be sharing the data, and this list may evolve over a period of time. It may become a little generic, which may indicate that, okay, they may give a hyperlink to indicate all the diagnostic centers or all the insurance houses, but there'll have to be a section to indicate who will be the entities who will be processing upon that particular data as well, how long the data will be retained for each of these use cases that we have mentioned for the purposes, what are the rights under the DPDP as regards the principal is concerned, how a person or a principal can withdraw the consent, how can he issue a grievance, and who could be the point of contact. This person would typically be the data protection officer appointed on behalf of the fiduciary, so that any grievance can be reported out to him. And that's the outline of notice that will essentially have to be given by fiduciaries and updated in real time as and when they continue to share the data, because usually what data is collected will be fairly consistent and fixed in that sense. What purpose will they use it for will also be fairly streamlined once they're gearing up for the compliance in 2027 when the date is coming up. And how long will they be retaining it, and all the other information. The only information that will essentially continue to evolve and modify or update will essentially be this information as to which all other entities specifically with whom the data is being shared. And this will have to be very, very accurately kept and updated by the fiduciary, essentially. And once this notice is there, and such notices being there by all the platforms and portals out there, the principal can essentially go to the consent manager, can essentially say, okay, for these 5 companies, I withdraw my consent, or for these 10 companies, I would like them not to share it with insurance companies, for example. And as a result of which, for that particular principal, all this data for insurance will essentially not have to be shared. And then any deviation from the same would obviously result in a breach, and as a result of which an application can be filed before, application in the form of a complaint before the DPO, Data Protection Board, as a matter of fact. I would probably hold my thoughts on the comparison because I think Elena will be probably most well suited, having sort of heard me in the last 10-15 minutes or so, to perhaps indicate practically where she thinks GDPR would deviate in terms of maybe the consent practices, maybe the notice practices that are expected to follow, and most particularly more keen with respect to with whom the data will eventually be shared, and the ability of a user to withdraw or amend that list of entities with whom the data is shared, and what specific data packets would he like not to be shared or perhaps agreeable to be shared. There is obviously a big section also in DPDP on how children's data processing would essentially be done with respect to children having below the age of 18, how their parental consent would need to be taken up, and how that data can essentially be used. And that's a very, very heavily gated verification as well as transmission of that particular data. So the ability of platforms or applications or engines to use the data and share it in particular with data processors, one or more data processors for data that pertains to children, is extremely heavily controlled and monitored. And likewise, even the penalty of any deviation in the same is kept at one of the highest levels of 200 crores in Indian rupee terms. Rights, again, from a data principal or owner perspective, would be the rights for the principal to access the data, the right to correct the data, the right to delete or erase the data, the withdrawal practice in terms of him withdrawing from one or more platforms, how he can lodge a grievance, and eventually his ability to nominate somebody upon his death or incapacity to control the manner of use of that particular data. Now, there are obligations which are corresponding. As you would appreciate, on behalf of the data fiduciaries, whatever the principal would have to indicate in terms of consent, they would have to put it on notice, immediately react in real time to any data breach, how to handle grievance, and so on and so forth, which I understand and believe that will be largely in parallel with GDPR, but we'll hear about it from Eleanor in that sense. So I think I just wanted to cap it up in the first instance of what I wanted to cover. And if there's anything left out, we can always, I can come back to my presentations accordingly and perhaps cover up anything specific. But this is broadly what the template and the overall intent of DPDP is. And, Eleanor, over to you if you have any comments on initial thoughts on DPDP, but otherwise we can jump right in and I will just share your presentation right away.
Wonderful, Taryn. Thank you so much. That was very interesting. And what strikes me is quite how similar the regimes are. I mean, they really are, a lot of the principles and the sort of fundamental idea that this is about, fundamental rights is absolutely the same. So I think it's going to be hopefully useful for all of you to hear about how GDPR has gone down in Europe, the problems we've had, and some of my top tips. And I'll come back perhaps at the end, Taryn, to talk specifically about this issue of consent, sort of once I've given that overview, because I think that is a very interesting area where there are some differences actually, but I think there are a lot more similarities than differences. So just a little bit on my background. So I'm a barrister and I'm a partner and head of data and privacy here at Marks & Clark in London. I've been working on data protection really since the GDPR came in 2018 and advising companies of every size, from the largest sort of big tech companies down to smaller organizations, SMEs and charities on how to comply with this legislation. But it wasn't really the start of my data protection journey, because I was a government lawyer before that, and I actually negotiated the GDPR on behalf of the UK as the lead lawyer. So I've seen this regime since it was first introduced by the European Commission in 2012, been to Brussels, negotiated, talked about the concepts. So it's been a fascinating journey, and I hope to be able to share some of those insights really right from the start of this process till now, and I hope you'll find it helpful and practical. So Taryn, if we could move to the next slide, I just want to set out how I'm going to structure this segment of the webinar. So I'll talk a little bit about the context. GDPR, 8 years on, because it's been in force for the last 8 years. Has it worked? And I think there are some interesting commentaries on that, which I'm going to very briefly touch on. Some top tips, because I think you can really get ahead here by thinking about the issues now in a way that's strategic and commercial. So I'm going to give you some top tips and give you some examples of clients I've had and the sorts of issues that we've found have arisen under this regime, which I hope will be useful for you in thinking about the DPDP when it comes in. And then finally, I'm going to look a little bit at enforcement and how that's worked under the GDPR. So if we move to the next slide, in terms of the session and the sort of learning outcomes. I used to be a lecturer, so I always have to have learning outcomes, I'm afraid. But hopefully you'll be able to be more strategic about your compliance program after listening to this. Stay ahead of the competition, because I actually think that compliance here can keep you ahead of the competition, which is hopefully going to be useful. And also protect against reputational risk, because we see a lot that if you're not trusted with people's personal information, they're not going to want to give it to you. So I think it's very important to think about reputational issues as well as legal ones. So if we move to the next slide. So this was really interesting. So Paul Nemitz was the head of the European Commission's negotiating team when we negotiated GDPR. And he was very pleased with the instrument. And he said, this is going to make Europe the trust centre of the world with the GDPR. Not everyone agrees with that. And if we move to the next slide, we can see some other commentators. So this is a couple of German academics who've said that data protection law is the perfection of a dead end. And I'll come on to explain a little bit, particularly in Germany, I think there's been quite a lot of criticism of GDPR. And actually, Germany has been quite active over the last few years and months in trying to get a few changes to our regime, which I think is quite interesting. So if we move to the next slide.
One second.
So this is a commentary from Dr. Winfried Wahl, who was actually the head of the German delegation when we did the GDPR negotiations. And he's written extensively on the rights and the obligations and whether they work. And one of his main points, he's written a really interesting essay, actually, which I've got a reference to at the end, called The Emperor's New Clothes. So you might be able to tell what he thinks of GDPR. But one of the specific points that he makes is that it is so onerous for organizations to comply with. There are so many tests that you have to go through to consider, are the individual's rights being respected here? Or can I, as an organization, say, well, actually, my need to use the data overrides the individual rights in this circumstance? And he says there are 80, he's counted them, 82 balancing tests where you're weighing up the rights of the individuals against the rights of the organization, 30 necessity tests, so questions about proportionality, is what I'm doing proportionate, and 77 references to the data subject's rights and freedoms, which the organization, the data fiduciary, as it will be called under your legislation, or is called under your legislation, 77 times throughout the GDPR that becomes something that you have to think about. And so that is very onerous. So if we move to the next slide, Winfried Wahl gave an excellent lecture a couple of years ago in Cambridge, which I attended. And he said, GDPR has made people so frightened that now in Germany, when you leave primary school, you used to get, was the tradition, a lovely book with pictures of you and your classmates that you could treasure and remember the rest of your life. Now, because of GDPR, people are so worried about sharing personal data, and of course, pictures also count as personal data under the GDPR, that they now obscure the pictures of all the classmates in this book. So the only person you can see in these pictures is actually yourself. And he says that is just absurd. But everyone has become so overcautious about this regime, and that is not in anyone's interests. So if we move to the next slide, here's another commentator, Bert-Jaap Coeps, who actually attended that same lecture in Cambridge. So I also thought his thoughts were very interesting. He said that GDPR is like this film, which is one of his favourite films, Alfred Hitchcock's Harry. And Harry is all about Harry has died and nobody knows what to do with the body. And he says GDPR is a bit like this. Again, I've given a reference to that particular article at the end. It was written in 2014, but a couple of years ago. But yeah, Coeps in this lecture in Cambridge said, actually, I could have written it yesterday. The issues haven't been resolved. And he says data protection law, rather like Harry, is also dead. And he goes on to explain why. So on the next slide, I'll just set that out briefly for you. He said the law is based on three fallacies. Firstly, the delusion that data protection law can give individuals control over their data. And as Taryn was very eloquently talking about, that is the point of this regime. But in Europe, at least, the control is somewhat illusory. Our data is collected all the time. And most of us don't have time to read the privacy notices that we get to ensure transparency. There was some research a few years ago that said that it would take I think it was 2 months of every year to read all of the notices, because we process our data so much every day. And so no one has time actually to do that. So that was his first point. Secondly, the idea that reform, so GDPR was meant to reform some previous European law. The idea that reform has actually simplified the law is also a fallacy, he said. It's become much more complicated. And as we saw from Dr. Winfried Wahl, there are so many tests that you have to think about when you're processing people's personal data. And the final fallacy is the assumption that data protection law should be comprehensive, so it should apply in every context in the economy in which you can process data. And again, he said that that really is not helpful. So this is a bit of the commentary that we've had. I think the European Union has really overregulated in this space. So GDPR is part of now over 100 pieces of legislation that apply in the digital space. And we've got to the point now where European lawyers actually can't tell you what the law is because it's just so complicated, which is really not a situation which is helpful. So yes, if we move to the next slide, a couple of years ago, the former chair, the president rather of the European Central Bank, former Prime Minister of Italy, Mario Draghi, wrote a report about all this over legislation in the EU. He talked about all the regulatory burdens, the fact that these were self-defeating, and he said more than half of SMEs in Europe flag regulatory obstacles as the greatest administrative and the administrative burden as their greatest challenge. So I think there is a sense now that we need to pull back a little bit on all this legislation. But if we move to the next slide, no one can agree on how to reform any of this, including data protection law. So as of last week, the member states decided that they couldn't have a meeting to try to finalise the proposed reforms to GDPR, which I have to say are very unambitious. It's just a few tweaks here and there. So there's no sort of fundamental rethinking of the architecture, but even those very small tweaks can't be agreed on. So there is a delay to the reforms, and I suspect they're not going to happen. So we're going to end up with the same regime, which some people say is the perfection of the dead end or dead, but others say this makes Europe the trust centre of the world. And I do want to come on to a positive message about GDPR on my next slide. I do think it has been really, really important for empowering citizens to do with their rights in relation to data. And in this fourth industrial revolution in the age of AI, the rights, I think, are even more important now than they were when we first started negotiating GDPR in 2012. They're absolutely crucial. In some ways, I think GDPR was almost ahead of its time and perhaps is coming into its time now because of AI and because of the way that our data can be used to make decisions about us, which we may not understand. The right of access, I think, is incredibly important in being able to ask, why did you make that decision about me and how did you make it? So I think it's actually a really important moment for data protection law. I think the other thing is, as I said earlier, trust is absolutely key. You do need to be able to explain to people that you're processing their data in a particular way and that you're keeping it safe. And research shows that if people don't trust how an organisation is using their personal data, then they may well not use that organisation for a particular service. So engendering trust and doing that through data protection compliance is really, really crucial. And as I say, I think this fundamental right to privacy in the age of AI is really, really important. So actually, I think GDPR, despite the onerous nature, is actually a very, very important instrument. And I think data protection rights, more than ever, are going to be crucial in this new fourth industrial revolution. So that's a little bit about the context. I'm now going to move on, if we could go to the next slide, to talk about top tips, because I've seen so many organisations interpreting this regime in a way which is a little bit unhelpful to them, actually, as well as, of course, to the individuals concerned. And we saw that picture of the child who only has in their book to remember their primary school years, their own face, but none of their classmates' faces, because they're all obscured. My real top tip is that data protection law should make sense. It is about fundamental rights. So if you're doing something that seems really quite innocuous, but important for your business, then usually you should be able to interpret the regime in order for you to be able to do that important thing, marketing your business or processing your employees' data. data protection law should make sense. And if you think I've got this very sensible thing that I want to do with someone's data, but it looks like I can't do it, think again and go back to this idea that this is a fundamental right, but it's a fundamental right that needs to be balanced. The individual's rights on the one hand and the rights of the organization on the other. And if you can puzzle your way through a proper balance between the two, and you can think, actually, yes, the individual has rights here, but the rights of the organization, the rights of other people are paramount. You know, that is something that we all need to get good at, I think, and not be too risk averse and not interpret the regime in a way that just doesn't make sense. So my first top tip is it should make sense. And you should be asking yourself, is the interference with that fundamental right permitted? So do I have consent, or is it otherwise necessary and proportionate? I know that consent sometimes isn't required under your legislation. So these will be thoughts that we have to think about here under GDPR that you also need to be thinking about under your data protection regime. And if you think, yes, actually, I think I can use the data, I do think I've got the consent, I do think that there's necessary reasons why I need to use it, that it's a proportionate interference in someone's rights, then go ahead, because the regime should make sense. So that's my first top tip. So if we can move to the next slide, my second top tip, and this is becoming more and more of an issue as we move into the age of AI and everyone is starting to use AI tools. It's not always better to be a data processor. And Taryn talked about the data processor, of course, earlier, and that they don't have direct liability to the data principal. So it sort of looks perhaps quite attractive to think, I'm just the processor, I'm just processing on behalf of the data fiduciary, and I don't need to worry about all of these very onerous obligations. We are finding more and more, and I just wanted to say as well that the data fiduciary under the GDPR is called the data controller. We are finding more and more that actually everyone has an interest in the data that they hold, and therefore positioning yourself as a data processor who's simply acting on the data controller, or in your words, data fiduciary's instructions, actually doesn't reflect how people use data nowadays. So I think at this point, before you've got all those obligations that have, they haven't come into force yet, think very strategically about the position that you want to take in the market. It's quite difficult to pivot away from the position you've taken. And it might superficially look attractive to say, I'm just a processor and I haven't got most of the responsibilities. And what I'm doing is simply acting on someone else's behalf. Do think about that very strategically, because we are finding more and more that actually almost everyone is a data controller because they all want to use the data for their own purpose in some way. So think very carefully about that before you go down the data processor route, because, as I say, this is becoming a distinction that actually is a little bit meaningless nowadays, because everyone, as I say, has an interest in the data. So I think that's something to think about early. And if we move to the next slide, another thing that I think is worth thinking about, and again, this is on this controller processor, data fiduciary processor distinction, we're seeing more and more that courts or regulators are very unlikely to accept, if something has gone wrong, that, oh, I'm just a data processor argument, because so often there is more of an interest in the data than simply acting on the data fiduciary's instructions. And where we see this issue coming to the courts and coming to the regulators, they say, no, sorry, you're not just a processor. And part of the reason for that is it goes back to the origins of this legislation as being all about fundamental rights. If you're just a processor, but you have managed to develop a very complex piece of AI, for example, which the data fiduciary may well not understand how it works, they've simply bought it. But in order, therefore, there not to be a gap in people's rights through which the rights under the legislative framework fall, it's much easier actually if everyone is a data fiduciary and not a processor, because then everyone needs to be thinking about transparency, fundamental rights, all of that sort of thing. So part of the motivation for the regulators and the courts finding that you're usually a data fiduciary is to ensure that there isn't a gap in that fundamental rights protection. So obviously we don't know how your courts are going to interpret these concepts, but if they start to look at European data protection law, they're going to be seeing the fact that the courts tend not to accept that data processor argument. So you need to be really confident that you're a data processor, I think, and look at it very carefully, and make sure that you've got all of your reasoning there, because it's a position that you can come under pressure with, and people may not agree with the position that you've taken in the market. So you do need to think very carefully and strategically about it. And actually, it's not a disaster to be a controller or a fiduciary. It just means you have to work a bit harder. But it does mean, when I go back to that concept of trust, that you have done all of that work that would allow people to trust you. And so I think it's a really important consideration early on. You know, where am I going to position myself in the market? What are the facts? What's the reality? And what are the courts and the regulators likely to find? So that's my top tip 2. So if we move on to the next top tip, because we're dealing with an area of fundamental rights, and fundamental rights are so context specific and sometimes so nuanced, you do need to actually have a human being thinking about the context when they're thinking about these rights. So often we see in the market tools which say, I can do all of your compliance for you. You don't even need to think about it. I can do all of your subject access requests, responses, simply using an automated tool. That often doesn't work. There is definitely a place for automation in this regime. I'm not saying that there isn't. I think there is, and I think it can be very, very helpful. But there are going to be some really, really difficult decisions, because we're looking at a regime which requires you to balance the individual's rights against the rights of the organisation, or the individual's rights against the rights of other individuals. The idea that a machine can work out whose rights should weigh heaviest or be the most important in that fundamental rights balancing test is just not possible at the moment with AI tools, because they don't understand context and they can't do that nuanced thinking. So yes, do use automation, but do turn your mind to those difficult issues, because there is a real risk that if you do all of your compliance simply as tick box and don't think about it, that you're going to be doing things. And I've had clients who've been using these kind of tools and been on the verge of disclosing incredibly sensitive information about their organisation and incredibly sensitive information about other individuals to somebody who's made a data subject access request, so asked for their data. Had we not done the human review as well, we would have ended up in a lot of difficulty. So do remember that this has also got to have some human oversight. It can't be just delegated to a tick box or to some sort of software. You do need to have people thinking about these rights as well. So my next top tip 4, it's so much better to have a proper compliance program in place than to simply be reacting to a crisis where someone's made a very tricky data subject access request, or you've had a data security breach. We've seen so many organizations who haven't had a proper incident response plan in place. I'm going to come into this in a bit more detail in a moment. But these are examples where you haven't got very long to react. If you haven't done your compliance beforehand, you are going to have to get loads of people on to manage that crisis, and it's going to be pretty stressful for you. So my absolute top tip 4 is do your compliance first. Plan for all of this. Get your teams trained. Know what's potentially going to hit, and keep your compliance updated. That's another thing that we've learned from GDPR. A lot of organizations did all of their compliance in 2018 when GDPR came in, and then didn't really think about it, didn't make data protection part of the culture of their organization, and then they get hit by one of these crises. And it is very time consuming, very stressful, and very expensive often to deal with that crisis, rather than just keeping your compliance going. And knowing when something happens, this is how we deal with it. So that's my top tip 4. My top tip 5 is that actually having good compliance is a commercial advantage. I've had clients who've actually done a lot to explain, particularly with AI, how the processing works, what it does with people's data, how their rights are affected. And that has actually allowed them to come to market much quicker because all of that thinking has already been done. That engenders trust, and that engenders trust in the organizations that you want to do business with. So actually compliance can be a huge commercial advantage. And we see these organizations that haven't done that not necessarily getting the deals and not being able to make as much business. So this really is, I think, a commercial advantage to turn your compliance into something that you can say to others, this is all under control. We know what we're doing here with this. And that actually does bring you more business. So do think about it as well as something which is not just a cost, but an investment that can bring you greater profits. Next top tip is here. Cybersecurity is a huge issue for everyone right across the world. It is so important to know what will happen if you have a cybersecurity incident, because unfortunately, it's now a question of when, not if. So you do need a proper incident response plan. And you need people to know what they're going to be doing in that situation. And you need to practice it before a response takes place, before an incident rather takes place, because it's much too late when the incident takes place to think, okay, let's cobble a plan together now. The timeframes are so short for reporting a personal data breach to the regulator. You just won't have time, and you won't have time to manage the many things that you have to think about during an incident. So get your response plan in place early and practice it so you know what you're going to do when the incident hits, and that will make it so much less stressful. So that is my top tip number 6. So these were my top tips. I hope they're helpful. I hope they're practical. There's a lot to think about here, but I think planning ahead, getting ahead is going to be not only useful from a compliance perspective, but also very commercially advantageous. And then coming on to enforcement, what are we seeing? What have we seen in Europe since GDPR came in? We've seen a lot of huge fines against the absolutely biggest US tech companies. Those are the ones that the European regulators have in their sights because they process the most data and they do the most with people's data. And they really, I think, to be honest, have a stranglehold of the European market, and the Europeans are not very happy about it, but that's the reality. If you're a smaller organization, the enforcement is pretty uneven, I would say. So we have seen massive fines from Ireland, but that is because the largest tech companies are headquartered in Ireland. We've seen some regulators, and the Spanish regulator is very interesting here. The Spanish regulator is incredibly active and does actually take even breaches by smaller organizations very seriously, and will levy fines, even relatively small fines, for breaches of the data protection framework. That's, I think, in marked contrast to the UK. Obviously, we're not in the EU anymore, but we still have more or less the same regime. The UK is doing almost no enforcement whatsoever. And the reason for that is that our ministers here in the UK are really keen for the UK to develop new technologies and for this to be a business-friendly jurisdiction to come to. And so I'll give you an example which I think has caused huge consternation amongst the data protection community in the UK. There was a spreadsheet which was disclosed by our Ministry of Defence of very, very sensitive names of people who had actually worked with the British Army in Afghanistan. That was disclosed, and actually some people were even were killed as a result of the disclosure of that information, and our regulator took no action whatsoever, and that has been a massive scandal in the UK. And a lot of people have said, well, if the regulator doesn't care about that, which is the most serious consequence of breaches of privacy, then why do I need to bother? And I think the answer to that, which I hope is also helpful for you, is that you really do need to bother, because even if the regulator doesn't care about your particular sector or your particular type of business, your consumers, the people that you interact with, the people whose data you hold, will care. So no matter what the regulators do, it's really important that you can demonstrate that you do take this responsibility of using people's personal data very seriously, because the outcome may not be as serious as in that particular case, but the outcomes can be very serious for individuals if their data is compromised. There can be financial consequences. There can be consequences to their reputation, information which is very sensitive, which they would not want to be disclosed, may be disclosed. And they may be having to do an awful lot as a result, for example, of personal data breach in terms of trying to make sure that there aren't adverse consequences to them and their families as a result of the disclosures. So yes, the regulators are important. Yes, the fines are important. But even more important, I think, is showing yourselves to be trustworthy organizations that take these rights seriously. So those are my sort of top tips. I hope that's going to be useful. I hope that was practical. Taryn, I don't know if I should come on quickly to talk about consent, because I think that is an area where there is quite a difference, actually. We try to avoid consent at all costs, because as you were describing, it is quite onerous. You have to be specific. You have to ask people, are you happy with the way that we're using your data? Under the European regime, it's a little bit more flexible. And so we don't tend to rely on consent. But when we do, yes, all the things that you've said apply, and you have to be very, very careful about how you're using that information. Here's a little bit about our practice as well. So we work on cybersecurity, artificial intelligence, and data and privacy. So very happy to have a chat with anyone who wants to get in touch about how we can help and some lessons learned from GDPR. Yes, so there's my contact details and some references in the final slides. I think we can circulate these, can't we, Taryn, perhaps, if people want them. Some of the reading as well, and the articles that I referred to earlier.
Absolutely, absolutely. I will share it across the platform on the website, etc. as well. Thank you very much, Eleanor. It was fantastically covered in an extremely short period of time. I wish we had a longer sort of a duration, because these case studies and the real life impact on cases is extremely important for Indian entities to understand, because there will be a floodgate of complaints filed before the Data Protection Board, as I see, when this regularization happens from the mid of next year. I had a bunch of questions myself, but we are at 3:51, which is another 9 minutes by the clock. We might extend by a few more minutes as well. But I think before that, before I sort of, if there's no question, I'll pitch in. But otherwise, I'll like to make the floor open. If anybody here, anybody who's attending would like to ask any question to Eleanor, please go ahead and unmute yourself.
Actually, hi, am I audible?
Yes, Soumik, yes.
Yes, so I did have a question for Eleanor. So if you look at the DPDP Act, it is not as onerous as GDPR, right? Like there aren't as many references as GDPR at least. So under Section 8, it has been said that where personal data processed by data fiduciary is likely to be used to make a decision that affects the data principle. Now I'm very curious that what is exactly meant by affect? Right, to what degree would an action qualify as affect, right? Would it just simply be targeting in marketing strategies, or does it have to be something more extreme?
Karen, I mean, I can give a GDPR answer, but I think perhaps you're best placed to talk about the interpretation of the DPDP.
Yes, I think, Soumik, in my limited view, I think this will evolve as more and more case laws come on it, right? I mean, obviously, sharing it with third parties that use it for commercial purposes could be one bit of it. The effect could also be putting it on a server which is not hosted in India and perhaps is more lesser amenable to the security provisions and therefore higher amenable to a attack in that sense, and therefore the user or the principal may get concerned based on where the data is essential. So it's not just what that data is, but where it is being stored, for what purpose. So the classification of purposes, the taxonomization of where the data is being stored would perhaps give an ability to the principal to evaluate whether that is affecting him in the long run, and basis which he can then mitigate or change his consent parameters essentially.
Got it. That actually helped. Thank you.
Sure. Yogita, you had a question? Can you unmute yourself, Yogita? Yeah, I think she can come back.
I have a question.
Yeah, Kriti, please.
So actually, I'm writing a paper on DPDP Act. So while writing that research paper, I have this one question which came to mind, that with the increasing use of personal data sets in these training and refining generative AI systems, do we believe that the DPDP compliance may eventually evolve from purely regulatory obligation into a material transaction risk factor, specifically in terms of merger and acquisitions, involving into AI-driven companies, like particularly in sectors of the like health sectors or merger sectors?
Yeah, I think there'll be a very long-term, very wide impact in my view, because we are obviously to test the system, right? Usually Indian companies try to templatize these things and have a particular consent manager in place. And the bigger companies will set the trend, and then the smaller entities would just sort of incorporate it in that sense. But you are correct, right? When we heard about the WhatsApp transaction that sort of took place, there was obviously a concern about data flowing in from Cred into the Meta side of things, and how that would impact. And with more and more M&As that would happen, it'll be an extremely difficult, and which is what Eleanor and I were sort of discussing, because when we looked at that template of notice that I had shown when I had started, that notice would indicate the parties to whom the data is being shared. And these parties would change on a day-to-day basis for any company, right? I mean, for a law firm like ours, we will have more and more vendors that we would tie up with. We will have more and more accounts with multiple AI platforms, with multiple other such engines on the search tools and the other tools for legal research, etc. And every time we've got to share some information, need not be personal information, but every time that information would need to be updated in the records of that particular notice, because there could be, for larger business houses, there could be hundreds of such vendors, which in the form of data processors, that the data would be stored and shared eventually with. So the initial bit of draft of the notice in terms of what data is being saved, for what purpose it is being saved, for what purpose it is being shared, all of that will largely stabilize. But this one section, which would indicate to whom it is being shared, for what purpose, and that will have to be very thoroughly updated and kept updated in real time, which is where the real compliance test, in my view, would come in. But only time will tell of how much and to what degree companies remain compliant to it, or whether it becomes just like a privacy policy, which is documented out in totality, and everybody uses similar templates without anything further thereafter.
I mean, but so if we see this could be very risky for the clients and for the because it's like basically invasion of privacy.
I completely agree. And Akriti, I think once a few of the data principles would start approaching the data protection board, and there are strictures passed and some penalties imposed, is when perhaps companies will take it up more seriously. Because even in IP issues, for example, the intermediaries earlier, Flipkarts and Amazons, had very little role to play, but now they have a very important and proactive role to play in issues of infringement, right? And all of this has come from orders from the respective high courts. And I think with time, therefore, even for DP issues, the more strictures that are passed by the data protection board, the more clarity and more pressure would come upon the entities to ensure that they are fully compliant and respect the data of the principles in that sense.
That would be right. Thank you so much, sir.
Sure. Any other question? Because we are about 2 minutes away. Anybody? All right. I had a couple of questions, Eleanor, if you
Hello.
don't mind. Yeah, go ahead.
Hi.
Start.
Thank you. Hi. So actually, I wanted to ask on behalf of startups that since we are filing many startup grants or maybe funded ones, so we submit our personal information in that, and so maybe it was DPIT or maybe our personal or any fund for any funds or venture capital, we give our personal data to that. Even government schemes also. So does that DPDP Act impose distinct obligations when transferring personal data to a government or organization or versus a private body? What is the distinction in that case? If as a keeping in mind as a small scale startup, what should we take care of in such cases?
No, I don't. I mean, usually the governments are responsible, and there's always an exception created for the government bodies in that sense, and therefore ability for DPIIT to use it for internal assessment purposes or share it with the Ministry of Corporate Affairs or with other such stakeholders that form part of the government architecture or the ecosystem would be something that is inherently allowed to the government authorities. The fact that it gets misused by a third party or a private party or shared with any other undesired party will be where a contention can always be brought in, Siddharth. But I think the DPDP Act does mention about sharing of data with government bodies like any other act, and their relatively wider rights and abilities to share it without, they'll have to put in the right provisions in their policies and practices, but obviously they have more flexibility in terms of being able to share it with other government authorities which are doing it for or not for profit purposes in that sense. But the specific section and rule, I don't have it in front, but there are some provisions which do indicate or govern how and when the data can be controlled when shared with a government authority.
Okay, thank you. Actually, I had one more question. Like the DPDP Act does treat employee personal data that we take from our employee differently, as or maybe the similar way that we have looked at for as a employee personal data or the GDPR. Like how does that work? If you can tell me a bit.
I would ask Eleanor. I mean, if Eleanor, can you define if there's some clarity with respect to how employee data will be different from data coming into another company from, say, a customer or from any other third party?
I mean, it's usually, some of it is very sensitive. So, for example, if your employees have health issues, that sort of thing. So we always regard employee data as being something you really need to be quite cautious about. And of course, everyone does have it. So I think very carefully about it. We've seen a lot of disgruntled employees making subject access requests on their departure from an organization. So I imagine, that's going to be an issue as well. So you do need to, I think quite carefully about ensuring that the rights are respected in relation to the employees, because they can sometimes cause quite a headache for an organization.
Sure. I think there's Soumik. Any question from your end?
Yes, actually, there's just one thing. Like, if you look at it from the organization side, very often vendor lists are kept incredibly private, right? Those relationships are protected by non-disclosure agreements and very strict penalties if you breach those, right? So, isn't this the death of privacy in that sense as well for companies, especially if you're sharing data?
Again, a fine line will have to be drawn, Soumik, because if that relationship is protected under privilege, for example, the necessity of sharing the data of a customer with that particular vendor or third party would need to be established as well. Right? Is it really necessary for the data to then go outside the scope of the fiduciary to that particular party whose details cannot be shared across? Now, that will be an interplay which will have to be done, because the principal would want to know which entities the data is being shared to. And if that relationship is privileged, then is the data sharing necessitated, is what the question would then come out to be. Because that balance DPDP would have to ensure and bring about, and the principal would have all the rights to ask or demand for that information with regards to, because otherwise everybody or every fiduciary will then start stating that this information is privileged or under confidentiality and therefore can't be disclosed.
Got it. Yeah, that makes
So
sense. Thanks.
I have one more question.
Yeah, Akriti.
So actually, I'm also interning at Khurana and Khurana. Right, I'm an intern there. So I just have this one question that as we see that DPDP Acts, it regulates personal data processing, but many generative AI, these systems are trained on data sets collected which are from the past, right, before the enactment of the legislation. In such cases, how will we decide liability? Like, how will we see the liability be accessed where historical data sets may not satisfy the present consent standards?
Yeah. So I think as far as that is concerned, again, we can go into the specific provisions of whether the act caters to it, but basic logic states that if, as of the implementation of DPDP, as of the date on which the companies are expected to keep compliance, if my data is with a AI engine, for example, at that point in time, and not based on historical information, but at that very point in time, they will have to immediately ensure compliance to it. But anything which happened in the history and is not therefore now in the records, but was used for training purposes, but if the company can come and certify or declare that they're not storing that particular data at this point in time, then they are obviously, right, no obligations towards the data principle in that sense. Provided they obviously give an undertaking that they're not storing any instance of the data as regards personal data of the principal is concerned.
Right.
Eleanor, I maybe one or two questions, Eleanor, that I had for you as well.
Of course, yes.
Assuming there's an entity called Unilever, right? In the hypothetical instance, how can a subject see how, from a GDPR perspective, how can a subject see how the data is being flowing as to the information that I had given as a data principal to Unilever or any other ex company in the UK, for example? Is that visibility there with the subject?
No.
So if tomorrow something happens, how do I establish whether Unilever shared it or some other entity did?
Well, they're the data fiduciary, the data controller. So everyone else in the chain is meant to be, processor, sub-processor, processing on their behalf, and they have to have the same contractual mechanism in place as you have with the processor. So that has to be flowed down the chain. So, and anyone who is a processor is going to be liable essentially for what their sub-processor does. So that's how the responsibilities work. But it's not at all apparent to the individual who's actually got the data. I mean, there has been a little bit of case law and guidance saying, you've got to be more specific in your privacy notices, giving transparency to the data subject than you've been in the past. So there's a bit more granularity. But the reality is, how are you going to, as you say, Taryn, keep updating? If you wanted to be entirely transparent, you'd have to be updating your transparency notice, every day. And I think this is one of the criticisms of the GDPR, certainly, that it's not really realistic in terms of the way that, businesses have to operate. So, and actually, I don't think the reforms, even if they get through, are going to really resolve that. So we have a bit of a gap, to be honest, between how we have to do things in business to operate and to make money and the standards that are required under the data protection law. They are not the same. Data protection law, I think, is set, the bar's set too high, quite frankly. And that is a rule of law issue. Every responsible organisation should be able to know what the law is and change their behaviour to comply with it. If you set the bar too high, then everyone is in breach of the law, and that's not a good situation to be in, and that is not good regulation, in my view.
No, absolutely. Also, do you see that in the European ecosystem, the whole GDPR compliance bit by companies which are smaller and SMEs is outsourced to one or some solution providers who say, don't do anything by yourself and we'll handle the entire compliance at our end? Is that a practice that has evolved? And what kind of companies are those usually?
I mean, we see that a lot. So we've got lots of people in the ecosystem who are, either smaller companies or larger established ones who offer sort of compliance as a service. But as I was saying, I think you have to be quite careful about that. I've had clients who've gone to those sorts of services and use them in quite sensitive circumstances. And we've said, look, we just want to check. We'll do a spot check of the documents, for example, which are about to be disclosed under a subject access request, which this compliance as a service company has sort of, it's run all your documents through the system and it says you can disclose these. And there's been things in there which, had they been disclosed, would have caused an awful lot of litigation. So you've got to be so careful, I think. And yes, I think some things can certainly be automated. And I think that is the way to go, because this, we can't all be spending all our time on compliance with this. But you really have to, I think, be strategic. You need to prioritize and you need to think about risk. Where are the highest risks and where do I need to put my resources in order to protect my company's reputation and protect it from a legal perspective?
And what you were also emphasizing about a lot of companies taking a position that they are a data processor and not a fiduciary. And obviously there are bigger obligations on the fiduciary, and therefore you said this, companies should have a long-term view on this. And then if they are partly a fiduciary, then it's probably better in the long run that they take the fiduciary position and make sure that their compliances are such in that sense. But I was also, while you were talking about it, I was wondering, there'll be some companies, obviously for certain customers or certain stakeholders, they will actually be a fiduciary, but for certain other people, they will actually be just a processor, right?
Yes.
It must be because they must be having different types of customers or maybe different business models within one company. And for some, they are acting as a processor. And does it complicate in that scenario, or is it that if they are either of the two, then a fiduciary is what they are?
It can be so complicated, and the EU regulators say you need to go through and in a granular way work out what you are for every single processing activity. I mean, quite how you do your compliance then is just so complex. And I think one of the dangers is that it can be quite unclear from an operational perspective which hat you're wearing. And then you might run a risk that you misposition yourself. And for example, you don't respond to a data subject rights request because you regard that as somebody else's responsibility, but actually they regard it as your responsibility. And it's when you've got those data subject rights requests and things might fall through the gaps that you might end up in front of a regulator. And I think they're probably likely to be very unimpressed with that. So to be honest, especially in the UK, we tend to take a slightly broader brush approach, and we don't go through, all the different 20 activities and put a sort of label on them. We say, if you're generally using the data for your own purposes, then just, take the fiduciary position. But the law is still not finished on all of this, and we don't quite know. But I've never seen a case where a data fiduciary is told, no, you're just a processor, and you've over-analysed people's rights and over-protected them. But they're just not going to say that because this is a fundamental rights regime. So I think if there's a question mark about which way you go, you're much better off doing the compliance and being a data fiduciary than taking the quite significant risk of doing none of the fundamental rights analysis, none of the protection, and then you end up being told at the end of the day, sorry, actually you were a fiduciary after all.
Sure. One final question, Eleanor, from my end would be, in the event of a cyber attack, and there are thousands of data principals that essentially get affected and their data gets compromised, for example, is it fairly easy, or do you think it sort of becomes like a norm where it becomes like a money making exercise for the principals in that case? That because they can always send back and ask the data fiduciary as to whether my data also got compromised in the cyber attack and thereafter claim damages for that particular breach, even though nothing materially might have happened to the principal's data, but it is established that the data did get breached out. So do you anticipate that happening, where when there's a large FMCG company and their data gets out, and it is very likely that my data was a part of that thousands of users, and then that one user will come and then sue them in Ireland or wherever in Spain and say that compensate me for that breach that happened?
Yeah, I mean, that is definitely a risk. In the UK, that sort of group litigation hasn't really got off the ground because for that individual, proving that anything actually happened to them is quite difficult. And the courts are not very interested in handing out money for, or forcing companies to hand out money for consequences that no one can actually tangibly evidence. But I think that we are going to see a lot more of this type of litigation, and particularly, I think, with AI and automated decision making, where the AI may have made faulty decisions about thousands and thousands of people, and their rights are significantly compromised. So their ability to take out a loan or their ability to receive state benefits or something like that. So I think, yes, this is going to be a real area of significant growth and change and risk, I think, in the future.
Sure. Eleanor, thank you so much. It was an absolute pleasure to have you. As I said, on a weekend, it's not easy because you're trying to wrap up multiple things. But thank you so much for taking out time for this wonderful and very relevant session. We might want to do a session 2 or 3 on this as well, where we probably do an even deeper dive in that sense, because it is a topic that will be of interest to companies across technologies or businesses for that matter, and each and everyone will have to do it. And we will surely, seek your support in case there is any, confusion that I think all of us, everybody has the coordinates. And thank you very, very much for joining us today for this, Eleanor.
It was such a pleasure, Taran. Thank you so much. I really enjoyed it, and it would be wonderful to do a deeper dive on other areas. That would be superb.
Thank you, Eleanor. Thank you, everybody, for joining in. It's been a pleasure. Thank you very, very much for staying around, and we are sorry for the 15 odd minutes of delay, but a pleasure to connect, and thank you very much for joining. Thank you. Thanks, Eleanor.
Thank you. Thank you.